Good morning friends, you're most welcome to Think Ice channel. Today we are going to discuss India Yearbook Gist 2022 which is written by JS Score. Our topic is Law and Justice. Let us begin the topic. Ministry of Law and Justice is the oldest limb of the Government of India dating back to 1833 when the Charter Act 1833 was enacted by the British Parliament. By virtue of this authority and the authority vested under him under Section 22 of the Indian Council Act 1861, the Governor General in Council enacted laws for the country from 1834 to 1920. Then there was Government of India Act 1919. The legislative power was exercised by the Indian legislature constituted thereunder. The Government of India Act 1919 was followed by the Government of India Act 1935. India became a dominion and the Dominion legislature made laws from 1947 to 1949 under the provisions of Section 100 of the Government of India Act 1935 as adopted by the India Provisional Constitution Order 1947. Adopted by the India Provisional Constitution Order 1947. Ministry of Law and Justice comprises the three departments, namely the Department of Legal Affairs, the Legislative Department, and the Department of Justice. National Mission for Justice Delivery and Legal Reforms. National Mission for Justice Delivery and Legal Reforms was set up in 2011 with the twin objectives of increasing access by reducing delays and arrears in the system and enhancing accountability through structural changes and by setting performance standards and capacities. The mission has been pursuing a coordinated approach for phased liquidation of arrears and precedency in judicial administration, which inter alia involves better infrastructure for courts including computerization, increase in strength of subordinate judiciary, policy and legislative measures in the areas prone to excessive litigation, re-engineering of court procedure for quick disposal of cases, and emphasis on human resource development. The criteria of judge population ratio for determining the adequacy of judge strength in the country has been reviewed by the Law Commission in its 245th report 2014 prepared on the direction of Supreme Court in this case. In this report, the Law Commission has observed that filing of cases per capita varies substantially across geographic units as filing are associated with economic and social conditions of the population. As such, the Law Commission did not consider the judge population ratio to be a scientific criterion for determining the adequacy of the judge strength in the country. In August 2014, the Supreme Court asked the National Court Management System Committee (NCMS) to examine the recommendations made by the Law Commission and to furnish their recommendations in this regard. NCMS submitted its report to the Supreme Court in March 2016. It has inter alia observed that in the long term, the judge strength of the subordinate courts will have to be accessed by a scientific method to determine the total number of judicial hours required for disposing of the case load of each court. In the interim, this committee has proposed a weighted disposal approach, disposal weighted by the nature and complexity of cases in local conditions. Judicial infrastructure. Until 2011, the central and the state governments used to contribute an equal share under the scheme, but from 2011-12 onwards, the central government was contributing 75% of the funds. In the case of northeastern states, the central government provides 90% of funding. Central funding is, however, subject to budgetary allocation of the scheme. E-Courts Integrated Mission Mode Project. The E-Courts Integrated Mission Mode Project is one of the e-governance projects being implemented in high courts and districts or subordinate courts in the country. The project has been conceptualized on the basis of the National Policy and Action Plan for Implementation of Information and Communication Technology in the Indian Judiciary 2005 by the E-Committee of the Supreme Court of India. National Litigation Policy. Government is said to be the major litigant, and there have been several law commission reports suggesting for a litigation policy to avoid unwarranted litigation by the government and thus bring down load on the court system as well as burden on the public exchequer. Therefore, the draft National Litigation Policy 2017 proposed to put in place a system which prevents, controls, and reduces litigation. Appellate Tribunal for Foreign Exchange. The Appellate Tribunal for Foreign Exchange was established in 2000 under Section 18 of Foreign Exchange Management Act FEMA 1999. Under Section 19 of FEMA, the central government or any person aggrieved by an order made by special director appeals or made by an adjudicating authority other than referred to in subsection 1 of Section 17 may prefer an appeal to appellate tribunal that may be filed within 45 days from the date of receiving the order by the aggrieved person or the central government. Enforcement agencies. All senior police posts in various states are manned by the Indian Police Services IPS cadre, recruitment to which is made on all India basis. The central government maintains central police forces, central police forces. The central government maintains Central Police Forces, Intelligence Bureau IB, Central Bureau of Investigation CBI, institutions for training of police officers and forensic science institutions to assist the states in gathering intelligence, in maintaining law and order, in investigating special crime cases, and in providing training to the senior police. Indo-Tibetan Border Police ITBP. ITBP is basically a mountain trained force, and most of the officers and men are professionally trained mountaineers and skiers. ITBP mountaineers have also successfully climbed peaks in Nepal, Iran, Japan, and South America. ITBP skiers have been national champions and have taken part in Winter Olympics. They have also participated in adventurous whitewater rafting through turbulent and mighty waters of the Brahmaputra, the Indus, and the Ganges, and also have international achievements to their credit in this field. Border Security Force BSF. BSF's role during peacetime is as follows. First, to promote a sense of security among the people living in the border areas. Second, to prevent trans-border crimes, unauthorized entry into or exit from the territory of India. Third, to prevent smuggling and any other illegal activities on the border. Fourth, anti-infiltration duties. Fifth, to collect trans-border intelligence. Its role during wartime is as follows. First, during wartime. First is holding ground in assigned sectors, limited aggressive action against Central Armed Police or irregular forces of the enemy. First is holding ground in assigned sectors, limited aggressive action against Central Armed Police or irregular forces of the enemy. Second is maintenance of law and order in enemy territory administered under the army's control. Third is gardening of prisoners of war camps. Fourth is acting as guides to the army in border areas. Fifth is assistance in control of refugees. Sixth is provision of sectors. And seventh is performing special tasks connected with intelligence including raids. Assam Rifles. The Assam Rifles' contribution towards assimilation of the people of the Northeast into the national mainstream is truly monumental. Their long association with the religion reflects in the forces being fondly called the Sentinel of the Northeast, and Friends of the Hill People, security in the northeastern region and guardianing the Indo-Myanmar border. National Security Guard (NSG), specially equipped and trained forces like SAS of UK, United Kingdom, Delta Forces of USA, United States of America, and G5G or GSG 9 of West Germany were raised abroad. The need for creating a special force for executing surgical operations based on tactical intelligence was felt in India when Operation Blue Star was carried out by the enemy at the Golden Temple, Amritsar in 1984. National Security Guard (NSG) was conceptualized and created after studying and analyzing a special force like SAS in the United Kingdom, GIGN in France, GSG 9 in Germany, Shar-e-Matkal in Israel, and Delta Forces in USA. Shar-e-Matkal. Sashastra Bal Seema Bal. Sashastra Seema Bal. Sashastra Seema Bal is guardianing Indo-Nepal border since 2001 and was also given the additional responsibility of guardianing Indo-Bhutan border in 2004. Its earlier aim was to build people's morale and inculcate a spirit of resistance in border population in the then NEFA, Northeastern Frontier Agency, North Assam, North Bengal, hills of Uttar Pradesh, Himachal Pradesh and Jammu and Kashmir with Ladakh. The area of operation was extended to other border areas in Manipur, Tripura, Jammu, Meghalaya, Sikkim, Rajasthan, Gujarat, Mizoram, South Bengal and Nagaland between 1965 to 1991. The role of SSB, Sashastra Seema Bal, in earlier setup includes: first, to inculcate a sense of security and a spirit of resistance in border population. Second, promoting national awareness and security consciousness. Third, organizing and preparing border population to resist enemy. Civil Defense. The Civil Defense Act 1968 was suitably amended by the Civil Defense Amendment Act 2009 in 2010 to include the disaster management as an additional role for the Civil Defense Corps while retaining its primary role. Although the Civil Defense Act 1968 is applicable throughout the country, the organization is only raised in such areas and zones which are tactically and strategically considered vulnerable from enemy attack point of view. Home Guards. Home Guards is a voluntary force first raised in India in December 1946 to assist the police in controlling civil disturbances and communal rights. Home Guards are raised under the Home Guards Act and rules of the states or union territories. They are recruited from various cross-section of the people such as doctors, engineers, lawyers, private sector organizations, college and university students, agricultural and industrial workers, etc. The Ministry of Home Affairs formulates the policy in respect of role, target, raising, training, equipping, establishment and other important matters of Home Guard organization. Expenditure on Home Guards is generally shared between center and state governments as per existing financial policy. Personal law. They are governed by different sets of personal laws in respect of matters relating to family affairs, that is marriage, divorce, succession, adoption, wills, etc. The subject matter of personal laws is relatable to entry 5 of the list 3 concurrent list in the 7th schedule to the Constitution of India, and hence the Union Legislature, namely the Parliament, and subject to the provisions of Article 254 of the Constitution. The state legislature are also competent to make laws in this field. Marriage. The Special Marriage Act 1954, which provides for a special form of marriage and the registration of such marriages, extends to the whole of India except the former state of Jammu and Kashmir but also applies to the citizens of India domiciled in Jammu and Kashmir. Persons governed by this act can specifically register marriage under the said act even though they are of different religious faiths. Section 36 and Section 38 have been amended to provide that an application for alimony or the maintenance and education of minor children be disposed of within 60 days from the date of service of notice on the respondent. An attempt has been made to codify customary laws which is prevalent among Hindus by enacting the Hindu Marriage Act 1955. This act, which extends to the whole of India except the former states of Jammu and Kashmir, applies also to Hindus domiciled in territories to which the act extends and those who are outside the said territories. It applies to Hindus in any of its forms or development and also to Buddhists, Sikhs, Jains and also those who are not Muslims, Christians, Parsis or Jews by religion. However, the act does not apply to members of any scheduled tribes unless the central government by notification in the official gazette otherwise directs. Provisions as regard to divorce are contained in Section 13 of the Hindu Marriage Act and Section 27 of the Special Marriage Act. Common ground on which divorce can be sought by a husband or a wife under these acts are adultery, desertion, cruelty, unsoundness of mind, venereal diseases, leprosy, mutual consent, and being not heard of as alive for 7 years, and being not heard of as alive for 7 years. In the Divorce Act 1869, comprehensive amendments were made through the Indian Divorce Amendment Act 2001 to remove discriminatory provisions against women in the matter of divorce and to provide for dissolution of marriage by mutual consent. Further, Section 41 of the 1869 Act was amended by the Marriage Laws Amendment Act 2001 to provide that an application for alimony or the maintenance and education of minor children be disposed of within 60 days from the date of service of the notice on the respondent. Adoption. Although there is no general law governing adoption, it is permitted by the Hindu Adoption and Maintenance Act 1956 amongst Hindus and by custom among a few numerically insignificant categories of persons. Since adoption is legal affiliation of a child, it forms the subject matter of personal law. Muslims, Christians and Parsis have no adoption laws and have to approach the court under the Guardians and Wards Act 1890. Muslims, Christians and Parsis can take a child under the said act only under foster care. Once a child under foster care attains the age of majority, that is 18 years old, he is free to break away all these connections. Besides, such a child does not have the legal right to inheritance. Foreigners who want to adopt Indian children have to approach the court under the aforesaid act. Maintenance. Under the Code of Criminal Procedure 1973, right of maintenance extends not only to the wife and dependent children but also to indigent parents and divorced wives. Claims of the wife, etc., however, depends on the husband having sufficient means. Under the Hindu law, the wife has an absolute right to claim maintenance from her husband, but she loses her right if she deviates from the path of chastity. Her right to maintenance is codified in the Hindu Adoption and Maintenance Act 1956. The Personal Laws Amendment Act 2019 further amended the Divorce Act 1869, the Dissolution of Muslim Marriage Act 1939, the Special Marriage Act 1954 and the Hindu Marriage Act 1955 and the Hindu Adoption and Maintenance Act 1956 so as to omit the provisions that are discriminatory to the leprosy affected persons contained therein. The Amendment Act came into force on March 1, 2019. The Muslim Women Protection Rights on Marriage. The Muslim Women Protection of Rights on Marriage Bill 2019, which replaced the Muslim Women Protection of Rights on Marriage Second Ordinance 2019, was enacted as Act 20 of 2019 on July 31, 2019. The enactment is for prevention of divorce by way of talaq-e-biddat by certain Muslim husbands in spite of the same having been set aside by the Supreme Court. This act is in force from September 19, 2018, that is the date from which the first ordinance, namely the Muslim Women Protection of Rights on Marriages Ordinance 2018. The Parsi Marriage and Divorce Act 1936. The Parsi Marriage and Divorce Act 1936 recognizes the right of wife to maintenance, both alimony and permanent alimony. The maximum amount that can be decreed by the courts as alimony during the time of matrimonial suits is pending in court is 1/5 of the husband's net income. The Divorce Act 1869 governs maintenance rights of a Christian wife. The provisions are the same as those under the Parsi law, and the same considerations are applied in granting maintenance, both alimony and permanent maintenance. Election laws and electoral reforms. The acts in connection with the conduct of election to Parliament, state legislature and to the office of the President and Vice President are: first, the Representation of the People Act 1950, the Representation of the People Act 1951, the Presidential and Vice Presidential Election Act 1952, the Delimitation Act 2002, the Andhra Pradesh Legislative Council Act 2005, the Tamil Nadu Legislative Council Act 2010. These are administered by the Legislative Department, Ministry of Law and Justice. Delimitation of constituencies. The periodic readjustment of the Lok Sabha and Assembly constituencies is mandatory in a representative system where single-member constituencies are used for electing political representatives. The electoral boundaries are drawn on the basis of the last published census figures and are relatively equal in population. Equally populous constituencies allow voters to have an equally weighted vote in the legislature. Electoral constituencies that vary greatly in population, a condition called malapportionment, violate a central tenet of democracy, namely that all voters should be able to cast a vote of equal weight. Delimitation and election are the two basic pillars of a parliamentary democracy. Equally populous constituencies allow voters to have an equally weighted vote in the legislature. Electoral constituencies that vary greatly in population, a condition called malapportionment, violate a central tenet of democracy, namely that all voters should be able to cast a vote of equal weight. Delimitation and elections are the two basic pillars of the parliamentary democracy. The first Delimitation Commission in India was constituted in 1952, the second in 1962, and the third in 1973. The third delimitation exercise, based on 1971 census, was completed in the year of 1975. The present delimitation, based on 2001 census, has been undertaken after 30 years. The population increased by almost 87%, and the nature of the constituencies in the country, by and large, had become malapportioned. Malapportioned. Although the rules for delimitation vary across countries, tasks involved in drawing boundaries are generally similar. In India, the drawing of boundaries generally entails allocating seats to the states and districts within the state, creating a database composed of maps, population, figures, and the details showing geographical, natural, administrative conditions of the area concerned, associating the statutory representative from the Lok Sabha and state assemblies, distributing the states and districts into geographic units called constituencies, having an extensive exercise of public input into delimitation process, summarizing and evaluating the constituencies, and passing and publishing the final order. The procedure of delimitation or delimiting the procedure for delimiting the constituencies in India stands clearly spelled out in the Delimitation Act 2002. With the issuance of the presidential order specifying the date on which the delimitation order notified by the Delimitation Commission shall take effect, it was necessary to amend the relevant provisions and the first and second schedules of the Representative or the Representation of the People Act 1950 to reflect the changes made by the delimitation orders notified by the Delimitation Commission. As a consequential requirement, the Representation of the People Amendment Act 2008 amending the Representation of the People Act 1950 in conformity with the delimitation was enacted and made effective from 2008. इसको repeat कर लेते हैं. With the issuance of the presidential order specifying the date on which the delimitation order notified by the Delimitation Commission shall take effect, it was necessary to amend the relevant provisions and the first and second schedules of the Representation of the People Act 1950 to reflect the changes made by the delimitation order notified by the Delimitation Commission. As a consequential requirement, the Representation of the People Amendment Act 2008 amending the Representation of the People Act 1950 in conformity with the delimitation was enacted and made effective from 2008. By this Amendment Act, the first schedule and the second schedule to the Representation of the People Act 1950 were replaced, including other amendments. Further, a new Section 8A, Section 8 Clause A, was inserted in the Representation of the People Act 1950, which provided that if the President of India is satisfied that the situation and the condition prevailing in Arunachal Pradesh, Assam, Manipur and Nagaland are conducive for the conduct of delimitation exercise, he may by order rescind the said deferments orders issued under Section 10 Clause A of the Delimitation Act 2002 in relation to any of the states and provide for the conduct of the delimitation exercise in the states by the Election Commission of India. Electronic voting machines (EVM). The use of electronic voting machine (EVMs) are started in the country on experiment basis in 1982. It took more than 2 decades for the universal use of EVMs, and during the general election to the Lok Sabha in 2004, EVMs were used in all polling stations across the country. The EVMs were developed at the behest of the Election Commission jointly with two public sector undertakings, Bharat Electronics Limited (BEL), Bengaluru, and Electronics Corporation of India Limited (ECIL), Hyderabad in 1989. The EVMs were developed at the behest of the Election Commission jointly with two public sector undertakings, Bharat Electronics Limited (BEL), Bengaluru, and the Electronics Corporation of India Limited (ECIL), Hyderabad in 1989. Voting rights to the citizens of India living abroad. Section 19 of the Representation of the People's Act 1950 provides that every person who is not less than 18 years of the age on the qualifying date and is ordinarily a resident in the constituency shall be entitled to be registered in the electoral rolls for that constituency. Section 19 of the Representation of the People Act 1950 provides that every person who is not less than 18 years of the age on the qualifying date and is ordinarily a resident in the constituency shall be entitled to be registered in the electoral rolls for that constituency. The Representation of the People Amendment Bill 2006, introduced on February 27, 2006 in the Rajya Sabha, and introduced a fresh bill, namely the Representation of the People's Amendment Bill 2010 in August 2010, to amend the Representation of the People Act 1950 to, first is, provide that every citizen of India whose name is not included in the electoral roll and who has not acquired the citizenship of any other country and who is absenting from his place of ordinary residence in India owing to his employment, education, or otherwise outside India, whether temporarily or not, shall be entitled to have his name registered in the electoral roll of the constituency in which his place of residence in India, as mentioned in his passport, is located. B. Provide that the electoral registration officer shall make corrections of the entries in electoral rolls and inclusion of names in electoral rolls after proper verification. C. Confer power upon the central government to specify, after consulting the Election Commission of India by rules, the time within which the name of person referred to in subparagraph above shall be registered in the electoral roll and the manner and procedure for registering of such persons in the electoral roll. The central government has issued necessary notification bringing the Act into force from February 2011. The Indians overseas can now furnish the document self-attested by them and get their name enrolled in the electoral roll of their respective constituencies. Thank you very much.